Hi. So continuing the important chapter of criminal law, this part covers the defenses available, categorization of offences and cases on the basis of court hierarchy and jurisdiction, some miscellaneous points, and of course few questions for a better understanding. The defenses. This is one such concept that doesn't need theoretical but practical understanding. Basically, questions. Kindly pay attention at the most frequently asked defenses, that is underlined, and the attached image. A reading of the bare Article 20 with the three subsections is crucial in this regard, especially for legal knowledge questions. The offences listed in the IPC are categorized or differentiated in three ways as shown here. A superficial understanding of these three shall do. Just note that non-bailable offence doesn't mean an accused can't get bail at all, and that provision of anticipatory bail is used when there is a reasonable apprehension of arrest by a person. These are the two crucial points here. Anticipatory bail is granted after taking various factors into account by the court. It is thus seen in totality that this categorization arises due to the wide ambit of criminal law itself. So the main aim of criminal law, the categorization in criminal law is to segregate the serious crimes with higher losses and the non-serious crimes, because law in itself covers a wide ambit. For example, petty thievery and murder and rape fall under the same category, that is criminal law. So they have to be segregated. So moving on, this hierarchy is important for legal knowledge as the jurisdiction in terms of extent of punishment is asked, which is the pecuniary or the jurisdictional issues. In the sessions court part, do not forget that the death sentence needs to mandatorily be verified by the corresponding high court, which is the paramount rule for death sentence verdict. All the limits have been highlighted in bold. Please just go through them and take note. Finally, here's a list of tips I've compiled that can be helpful for this chapter. Apart from the four mentioned, read sections of other various common offences that you frequently see popping up for a higher confidence if a new tough principle comes up. One simple reading of the bare section of IPC would do, as then familiarity is achieved, which goes a long way. Because I'm sure many of us will get confused or thrown off guard if we see a new principle in the typical legalese, a complicated language with reiterations and commas everywhere. So it is important to be familiarized with sections, which, as I have written, have been copied verbatim for principles many times. So going to past year questions now, mostly asked from the defenses subtopic. A fairly easy question, so I'm sorry, just please do pause the video if you have to glance through the principle and facts. So a short trick for this question would be glancing at the keyword in both the principle and the facts. The keywords are good faith, which is mentioned in both the principle and facts and around which the question revolves. So through that, it is confirmed that A is in fact innocent, and so this question can be solved in max to max 10 to 15 seconds. So first of all, you notice one important thing about this question before reading it, that the principle and the facts vary in length, and substantially in fact. So this is a classic example to use the trick I mentioned earlier in the first video of criminal law. That was to read the facts first if they are substantially shorter than the principle itself. So once it's seen what the question is about, only the particular word should be looked for in the principle, and to verify whether or not the principle has been changed to confuse examinees or not. For example, in this question of CLAT 2014, it is known that self-defense can be used against even mentally challenged citizens. It is known as a fact, and we must have learned this during legal knowledge section, during legal knowledge preparation. So on reading the facts, we are aware that the question is asking just that fact. It is testing that knowledge itself. So we can quickly choose the right option. That is option A. But it is safe to confirm in the principle whether they have changed the general rule or not. Basically, if they have made the principle opposite to the known fact or the known belief or not. This ideally cuts down the time by at least half. So just confirm if the principle has not changed words, like inserted words like not or added a negative thing, and then you can arrive at your answer just via facts. So this is a pretty direct but controversial question that appeared in the 2015 paper. Controversial because it is vague and ambiguous to an extent. That is because we aren't sure if the man was in fact of unsound mind or not. Like, it can be debated highly. So according to me, it would best be to leave such questions in CLAT. It would be best to leave these questions in CLAT. In ALAT, of course, you should attempt them. Going to the last question. So we shouldn't get involved in the story provided in the facts, and just note that the principle requires a sudden provocation and a reaction to it. And if we just glance through the facts, we can see there is a 15-day time gap mentioned. So thus the answer should be jumped to at an instant, because the condition hasn't been met as mentioned in the principle of sudden reaction, of a reaction to a sudden provocation. So the answer is C. So that's it for these topics. Specific offences in criminal law like murder, theft, etc. will be covered in the next video. Thank you and good luck.